your right hand. Do you swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Should appear whenever you're set.
Thank you very much, Your Honor. Sir, good morning to you.
Good morning.
Please introduce yourself to the jury by saying your name and spelling your name for the record.
My name is Tyler Meter, Tyler, last name Meter, Meader.
Mr. Meter, are you employed, sir?
Yes, I am employed at the Lake County Crime Laboratory.
Right. And what is your position at the Lake County Crime Laboratory?
I am a forensic analyst.
Okay. What is your educational background, sir?
I graduated from Mercyhurst University with a Bachelor's of Science degree in Applied Forensic Science with a concentration in forensic chemistry.
Okay. And so you got that degree. What did you do with it?
After I completed my degree, I started my career at Valspar in their analytical department. Then I transferred to Euclid Chemical as an analytical chemist. Following that, I got employed at the Lake County Crime Laboratory.
What did you do as an analytical chemist?
As an analytical chemist, I used analytical instrumentation to test concrete admixtures, testing their pH, their purity, their concentration, and what was composed of all the admixtures to test our concrete.
What sort of equipment did you use to do that?
FTIR, Fourier Transform Infrared Spectroscopy, and GCMS, gas chromatography, mass spectrometry.
Okay. I'm going to ask you some more questions about that equipment later.
Okay.
But you began using that equipment earlier in your career, correct?
That's correct.
All right. Do you hold any certifications, sir?
I have a certification through the Ohio Department of Health to test bodily fluids for the presence of alcohol.
Okay. As a forensic analyst at the Lake County Crime Lab, what do you do?
As an analyst at the crime lab in the Controlled Substance Department, I test solid dose evidence for the presence of controlled substances, as well as testing pieces of evidence that contain residues for controlled substances as well.
All right. I should ask you, what is the Lake County Crime Laboratory?
The Lake County Crime Laboratory is a full-service laboratory that services all of the agencies in Lake County for evidence for forensic evidentiary value.
Okay. Now, how long have you been employed at the Lake County Crime Laboratory, sir?
A little over 6 years now.
And always in the capacity of a forensic analyst?
That's correct.
Okay. You have two different positions as a forensic analyst, toxicology and testing controlled substances. Is that right?
That's correct.
Okay. How long have you been testing controlled substances at the Lake County Crime Laboratory?
For the past approximately 5 to 5.5 years.
Okay. What were you doing for those first 6 months?
The first 6 months I was primarily focusing in toxicology and starting my training program. The training consisted of an extensive year-long watching, observing, reading all our procedures, protocols, and then supervised casework prior to being able to do casework myself.
Do you belong to any professional associations, sir? Do you have any memberships?
Yes, I'm a member of MAT and MAFS. MAT is Midwestern Association for Toxicology and Therapeutic Drug Monitoring, and MAFS is Midwestern Association for Forensic Scientists.
Okay. Do you participate in any continuing education as it relates to your work in analyzing controlled substances?
Yes, I do annual continuing education, whether that be attending conferences, watching webinars, etc., just to stay on top of the trends in the field and talk with different colleagues in different areas of the country and the state.
Okay. Have you ever testified in the capacity of an expert in the field of forensic analysis controlled substances?
Yes, I have.
Okay. Where?
In the Lake County Court of Common Pleas.
Okay, so this court, right?
Correct.
And how many times have you done that?
Approximately 15 times.
Okay. Now, I asked you earlier, what is the Lake County Crime Laboratory? You explained it. Are there different sections of the Lake County Crime Laboratory?
Yes, there are a few different sections in the laboratory. We have a DNA section, a fingerprint section, firearms, trace evidence, toxicology, and then controlled substance department.
Okay. And in the controlled substances department, how many analysts are there?
There are 3 analysts and a supervisor who is also an analyst, so technically 4.
Are you familiar with the procedures employed by the Lake County Crime Laboratory in terms of receiving evidence to analyze?
Yes, I am.
Okay. Before I ask you that question, how many controlled substances analyses have you done over the years?
Hundreds, if not thousands, of different types of controlled substance analyses.
Okay. All right. So, what are the procedures that are in place at the Lake County Crime Laboratory for accepting evidence to test?
In order for evidence to be accepted into the laboratory, it has to be submitted by an outside police or fire agency, meaning a lay person cannot just come to the crime laboratory and submit evidence. With that being said, the evidence has to be sealed with a piece of tape over the seal as well as initials to ensure that nothing can get in or out of that piece of evidence. And then it has to be accompanied by an evidence submission form. And then our evidence custodians up front will accept that evidence and create an electronic case file and file that piece of evidence within that case.
Okay. So if that evidence is not sealed, the crime lab won't take it in, right?
That's correct.
Oh, you know what? I neglected to ask you. Is the Lake County Crime Lab accredited?
Yes, we are accredited by ANAB, which is the ANSI National Accreditation Board.
What does that mean?
To be accredited, it means that our laboratory is held to the highest of international standards, meaning that we meet and adhere over 100 different requirements set forth from ANAB, consisting of employee records, our policies, our procedures, how we report our evidence, so on and so forth. They come into our lab once every 4 years and audit each and every section to ensure that we are doing everything properly as we say we are.
Okay, and you said that's international standards?
That's correct.
Okay. And if you exact those standards, then you're deemed to be certified by ANAB, correct?
That's correct.
All right. How does the Lake County Crime Laboratory keep track of the evidence that is submitted for analysis?
Our evidence is tracked via its chain of custody form, which is located in our LIMS, Laboratory Information Management System. And within that system, each evidence is filed under a case number, which we have documentation of, and it is stored in our locked evidence cage.
Okay. So a police agency brings in an item that they are going to request to be analyzed. It is made sure that it's sealed. Who takes it in?
Our evidence custodians will take in that evidence.
And what do they do at that point?
After they take in the evidence, they will then transfer the evidence from the police agency to themselves and then transfer that into our evidence cage.
How do they transfer it?
They transfer it via a unique barcode that is placed on the evidence by them, so the location of each individual piece of evidence is tracked at all points in time.
Okay. And this barcode that you're talking about, is it a sticker?
Yes, it is a sticker.
Okay. It's placed on the package, correct?
Yes.
All right, now you mentioned a locked evidence locker. What is that?
The locked evidence room, we have a keypad that we have to enter a unique code to get in. Once we are inside of that locked room, the evidence is inside of another locked evidence cage. It's another padlock. We have to enter a code to get into there. So 2 sets of security we need to enter to get into our evidence cage.
Who has access to that room?
Just the laboratory employees.
So once the evidence is accepted by the crime lab, it is locked in this secured room?
That's correct.
So if a police agency requests that a substance be tested for the presence of controlled substances, how do you, an analyst, know that?
We know that because the evidence custodians will create the electronic case file, and we will also get a physical folder and place in our bin outside of our room notifying us of a case and pieces of evidence that need to be tested.
Okay. So as the analyst, you come in, you see the folder, and you say, we got one, right?
That's correct.
What do you do at that point?
I will retrieve the folder from the bin. I will look at it to see how many pieces of evidence that I need to take. I will then go to the evidence cage and retrieve the piece of evidence that go with that case. I'll match the case number to the barcode number to make sure that those evidence belong to that case, and then I will take it into my possession, into my workstation, and start analysis.
When you take it into your possession, is that monitored?
Yes, it is monitored via the chain of custody, via the unique barcode identifier.
Okay, so when you say you transfer it into your custody, you're actually putting it into the system that you have it now, correct?
That's correct.
All right. So now you're in the evidence room, you have it in your hands, you transferred it to your custody, what do you do?
I will then take it to my workstation. I will place it on a bench top behind the actual workstation. I will clean my workstation.
Let me stop you for a minute. Your workstation, where is that?
My workstation is within the controlled substance department, which is segregated from the rest of the laboratory.
Okay, it's its own department, right?
That's correct.
Where controlled substances get tested?
Yes.
What is the layout of the area where you test these substances?
The layout of the area consists of a rectangular room with a folding table in the middle where we will place our evidence before analysis. On the other side, so the middle of the room, we have our table. The other side of the room, we have a clear bench top with all of our instrumentation, as well as a computer that we can track to, write our notes, do our documentation, and so on and so forth.
Okay. Now, sir, when you testified and you explained the other side, you pointed your finger over your shoulder.
Yes.
What does that mean?
So we have a table against the wall that I will open the evidence on.
Okay. So you come in, is there any equipment that you use prior to unsealing that package and taking evidence out?
Prior to opening the evidence and taking anything out, I will clean my workstation, and I will only ever open one piece of evidence at a time.
Okay. How do you clean the workstation?
We have a bottle of methanol. It's our cleaning solvent. Squirt the workstation, clean it down, and also clean any possible utensils or equipment that I will use while touching that piece of evidence.
Okay.
As well as wear PPE consisting of a lab coat, gloves, an N95 mask, and goggles if I would choose so.
Okay. Do you do that prior to testing these substances?
Yes.
Whatever comes in? Okay. So now you have a clean station, you have your PPE on, you got your gloves, and what do you proceed to do step by step? Please explain to the jury.
Step by step, I will look at the evidence submission form. I will look at evidence item number 1. I will take that from the table, again, make sure that evidence item 1 matches all the numbers, correspond with each other, and then I will open it. I will put the date on the packaging as well as my initials stating that, yes, I opened that piece of evidence on that day.
Okay. If you have multiple submissions that you have been requested to test, is there a procedure that you employ to keep them separate?
Yes, the items that I am not testing are on the initial folding table behind me, and the piece of evidence that I'm opening is on my actual workstation. So I'm opening 1, items, say 3, 4, and 5 are behind me. When I'm done with 1, I put that on the table, take 2, so on and so forth. So only 1 piece of evidence is ever in front of me at one given point in time.
Do you prepare the workstation in any way between testing each of these separate substances?
Yes, in between each piece of evidence that I open, I will, again, clean my workstation and clean any utensils that I may need or come in contact with the evidence prior to opening it.
Okay. Now, you were analyzed some substances relevant to this case, correct?
That's correct.
Okay. There were swabs that were submitted to the Lake County Crime Lab for analysis, correct?
That's correct.
Okay. And were you the analyst who tested these swabs that we're going to talk about here today?
Yes.
Now, sir, through the course of my questioning, there's been evidence presented in this case where we're dealing with fentanyl. Okay, right?
Yes.
Okay. Is there a label that gets affixed to packaging that contains fentanyl at
Yes.
the crime lab? Go ahead.
After testing is complete and I have identified fentanyl or a fentanyl-related compound, we place a potent opioid sticker on the back of the packaging heat seal that, and then take pictures so we do not have to bring that evidence into the courtroom.
Okay. And did you take those pictures?
Yes, I did.
Where?
I took those pictures at the crime laboratory.
When?
After analysis was completed and my report was released.
Do those pictures depict the substances that you tested in this case?
Yes.
Your Honor, I'll ask for continuing permission to proceed.
You may.
Mr. Meter, your handing has been marked as State's Exhibit 13A through U. Okay? Please take a look at those and let me know when you have an opportunity to look at those.
I've reviewed the pictures.
Taking a look at those. Do you
Yes.
recognize the State's Exhibits 13A through U?
Yes, these are the pictures that I took of all of the evidence that I analyzed in this case.
Okay. This is the packaging after you completed the testing and you heat sealed it?
Yes.
Okay. Do these pictures fairly and accurately depict that in the State report too?
Yes, they do.
Your Honor, move to 13A through U.
Any objection?
Pardon?
Any objection to
No.
admission? All right, 13A through U will be admitted.
Your Honor.
Excuse me.
Mr. Meter, I'm just going to keep those pictures in front of me here. I'm going to ask His Honor to display on the computer, and I do have 13A up on my screen, Your Honor. Now, Mr. Meter, this is a pointer. You see that green line there?
Yeah.
You press that button, then a laser comes out. Is there a power button on this?
One side, yes, sir. You look, check the green.
Mr. Meter, what are we looking at here, sir?
We're looking at evidence item 1, the barcode that I spoke of earlier today, right there. It says the case number, the item number, 51324, and my initials is the date in which I opened this piece of evidence.
Okay, now there appears to be a rectangular white box towards the upper left portion of 13A. What is that?
This right here, that is an annotation that I put on this picture so that it's easy to identify the case number and item number that this belongs to.
Now, when you say case number, what case number are you talking about?
Case number I am talking about is the unique case number that the Lake County Crime Lab assigned to this case.
Okay. Now, this is the item that you tested. Is it inside of that?
Yes, it is inside of the manila envelope.
Okay. I'm going to move to 13B as in boy. Okay. What are we looking at here, sir?
State's Exhibit 13B is a zoomed in picture of the barcode as well as the date and initials myself.
Now, you mentioned an item number, and if you can use the pointer, can you show where the Lake County Crime Lab assigned item number is depicted in this photograph?
Yes, so the case number is that number right there, and item number at the bottom left of the label, item number 001.
Okay, so when you say case number, you're talking about Lake County Crime Lab case number.
That's correct.
Okay, and that item number 1, who assigned that number?
Item number 1, the evidence custodians will assign the evidence those numbers.
Okay. All right. Now, closing, and I want to go back to 13A for a moment. I'm going to depict that on the screen. That rectangular white where you made the annotation, the case number, there's a dash and a 1. What does that mean?
The -1 on the box at the top signifies the case number as well as the item number. So
Okay.
this is depicting case number 230597-1, meaning item 1 within this case.
Okay. So as we look at A, and then we look at 13B, we can tell item number 1B is the same as A. Is that right?
Correct.
And looking at 13C, this annotation here, that's the crime lab number and the item number again, sir?
That's correct.
Okay, and throughout these photographs, if that insert, that white rectangular box insert is there with a case number and an item number, is that consistent throughout all of the substances that you tested here?
Yes, it is.
Okay. And that will identify the item number?
Yes.
Okay. So 13C is what?
13C is the back of evidence item number 1, showing the potent opioid sticker right there, as well as the barcode that you can't see, so that's why I blew that up, so we can see that better.
Okay, now you said sticker. There's a lot of stickers up there. With your pointer, you pointed to the green sticker, right?
Yes, the green sticker is a sticker that I placed on the evidence myself when sealing.
Okay. Are your initials anywhere else here depicted on 13C?
Yes, my initials are also in the black Sharpie on our barcode label.
All right, why did you put your initials there?
I put my initials on barcodes stating that, yes, I opened this evidence, I looked at this evidence, I tested this evidence. It's a notation for me if I were to go back and say, if my initials are on there, I did this piece of evidence.
Okay.
You tested it.
I'm sorry, I interrupted you.
No, go ahead. I was finished.
Okay. Towards the top, I see a horizontal blue tape.
Yeah.
Okay?
Yep.
And there's some initials there. Whose initials are those?
Those are also my initials. I sealed the manila envelope inside of the heat-sealed plastic bag with my initials over that tape seal.
When did you seal that?
I sealed that prior to taking the pictures of this piece of evidence, after analysis was complete.
And did you put something inside of that envelope prior to sealing it?
Yes, the cotton swabs that I tested are inside that manila envelope.
Okay. So you unsealed them, took them out, tested them, put them back in there and sealed it. Is that right?
That's correct.
Now, Mr. Meter, moving on to 13D as in David. Okay. You see that?
Yes.
All right. What are we looking at here, sir?
We are looking at evidence item number 2 within the same case folder. The barcode is right there, as well as my initials and date in which I tested this piece of evidence. This is the front of that piece of evidence.
Okay, and then the rectangular white insert, we have the case number dash what?
Case number dash item number and then my initials.
Okay, and what is the item number on 13D as in David?
Item number is 2.
Okay, so we're looking at the second set of swabs that you tested here, is that right?
Yes.
All right, and moving on to 13E, what are we looking at here, sir?
Can you approach for a second, please?
Yes, Your Honor.
You may continue, Mr. Shapiro.
Thank you, Your Honor. Now, Mr. Meter, looking at 13E, I asked you a series of questions about 13B. We zeroed in on the barcode. Similarly here, item number 2.
That's correct.
Okay, that's where we look to see which one we're looking at, correct?
Yes.
All right, and moving on to 13F. This is the back of Lake County Crime Lab, item number 2. And just like I asked you with the other, go ahead and explain.
Yes.
We got a case number and an item number in the box, right?
Case number, item number, I placed that. Our potent opioid sticker that I placed right there. The evidence barcode right there, as well as my initials on that barcode.
Okay.
And this
No,
is
I-
evidence
I mean,
item 2.
We were provided this in discovery prior to coming in, and we don't have any issue with the identification of these. We can stipulate that they are, as he's been testifying, they're all consistent.
Thank you.
Thank you very much, Mr. Deeb. Thank you, Your Honor. Mr. Meter, the series of photographs from 13A to U follow the same sequence, correct?
Correct.
Okay. So, before I showed you those photographs, now we've identified the substances inside of those envelopes that you tested. How did you test these swabs in 13A through U?
I tested the swabs in States Exhibit 13A through 13U. Like I said previously, I only open one piece of evidence at a time. Clean workstation, have my PPE on. There's 2 swabs consisted in each of the evidentiary items 1 through 7. Each swab, I have a vial, a small GCMS vial, full of methanol. I took the swab, dipped it in the methanol, swirled it around to try to withdraw any controlled substances or drug that was inside of that cotton swab, so now it could possibly be in the methanol solvent solution. I repeated that process for items 1 through 7, and then I ran that vial on the GCMS instrumentation.
All right, again, you did these separately, right, sir?
Yes, that's correct.
And how did you run it on the GCMS? What does that mean?
The GCMS is an analytical instrumentation that we use to identify and confirm any controlled substances in the piece of evidence. The GC is short for gas chromatography. That means that it can separate any and all substances in a mixture. In the mass spectrum, the MS for short, will fragment and identify each of those pieces apart. So the GC will separate and identify any and all components in a mixture.
Okay, and how does it do that?
It does that by, I like to use the analogy with the GC, think of a marathon race. All of the runners start at the start line all in a bunch, and as the race progresses, the runners will gradually separate out, and that is what the molecules will do in the GC column. They all start at the front, and as they travel through this column, they separate out, and then they enter the finish line or the mass spectrum, which they identify each and any component that comes through the column.
So you put these substances in this machine, it reads it in the way that you've testified about, and how do you, the analyst, know what it read?
I, the analyst, know that it read prior to, I should have said this earlier, prior to doing analysis, I will do QC, quality control, on that GCMS instrumentation to ensure that it is in working order prior to analysis. After the process that I explained, GC separates, MS identifies it, I will then compare it to known standards run on that instrumentation to ensure to match the retention time and the fragmentation pattern of the GCMS. So you have your unknown samples, A, B, and C. You can match A to a known library that I create on that instrumentation to ensure that that substance is indeed what I'm going to identify it as.
So as you tested the swabs that were submitted in this case through the GCMS machine, what did you find?
I found that the swabs contained fentanyl and 4-ANPP.
Okay, and fentanyl is a Schedule II controlled substance?
Yes, and 4-ANPP is also a Schedule II substance.
Okay, and are they fentanyl and 4-ANPP fentanyl-related compounds?
Yes, they are.
Okay. The GCMS, you testified it is testing for the presence of a controlled substance. Is that correct?
That's correct.
does the GCMS machine test for concentration of that substance?
No, it does not. It just tests for the presence of that
Okay,
substance.
so it's not the strength, it's just whether any of it is there.
Yes, whether it is there or it is not there.
Sir, did you summarize your findings in a written report?
Yes, I did.
I'm handing you, sir, what you marked as State's Exhibit 14. Please take a look at that.
I've reviewed the report.
Okay, do you recognize State's Exhibit 14?
Yes, this is an accurate copy of the report that I generated in this case. The original copy is filed electronically in our LIMS system
Okay.
at the laboratory.
Looking at the third page of State's Exhibit 14, does it contain a signature?
Yes, the third page contains my signature.
Does it have a signature on it?
Yes.
Do you recognize that signature?
Yes, it's my signature.
It's your signature? Did you put it on there?
Yes.
This State's Exhibit 14 fairly and accurately depicts that which it purports to?
Yes.
Move to admit State's Exhibit 14.
No objection.
I will be admitted.
Thank you. Your Honor, if I may, I'd like to put State's Exhibit 14 on screen. Mr. Meter, see if I can zoom in at all. This is your digital copy of your report, correct?
Yes.
Okay, can you please explain the different sections of the report?
Top of our report, Lake County Crime Laboratory, who issued the report. The accreditation that I spoke of earlier, we have our accreditation symbol on there as well. We have the case subject. We have our laboratory case number that the laboratory issued. The agency case number from the submitting agency, the case officer, and the submitting agency is located on this report.
Okay, and then we have the evidence submitted. These are how the evidence came into the crime lab and were accepted, correct?
That's correct.
The different evidence item stickers that you identified in State's Exhibits 13A through U, do they correspond to evidence item 001 and so forth?
Yes, they do.
Okay. Moving down to the bottom of page 1 and on to page 2, the results section, please explain what we're looking at here.
So the results for evidence item 001, they were found to contain despropanol fentanyl, otherwise known as 4-ANPP residue, Schedule 2, as well as fentanyl residue, Schedule 2.
Okay, and going through each of the evidence items, we have 2, 3, 4, 5, 6, 7. Looks like 2 through 6 all contained 4-ANPP and fentanyl. Is that right?
That is correct.
All right, and then number 7 contained fentanyl, Schedule 2.
That is correct.
Okay. Was it possible for you as an analyst to have come up with a weight of these substances?
It was not possible.
Why?
In order to obtain a weight for a substance, there has to be a physical weighable amount. With this being a residue, you cannot weigh the amount. It would be the weight of the Q-tip, which would inaccurately represent how much sample is actually on the Q-tip.
So you didn't have enough of it to weigh, right?
Correct.
But the substances on those swabs were fentanyl, correct?
That's correct.
Mr. Meter, the opinions that you've testified to today, did you make them within a reasonable degree of scientific certainty?
Yes, I did.
May I have one moment, please?
You may.
Thank you. Mr. Meter, I have no further questions for you, sir. Thank you.
Mr. Deeb, cross-examination.
Thank you, Your Honor. Shapiro.
Sir, good morning.
Hello, Tyler.
Hello.
I don't really know you that well, but I got to meet you last night on the way out, right?
That's correct.
All right, so here we are talking finally. I'm not going to contest the findings of fentanyl. I just want some more of an explanation, if I may.
Okay.
I'm curious about fentanyl. With your position, you must be well versed in fentanyl, its effects, what it looks like, how it can be used, those sorts of things.
Within my position, I have a general idea of how it is used. However, the effects on the body and interactions within each individual's body is not within our realm of expertise in testing at the laboratory. Our sole purpose is just to identify the substances that we find.
So you're not like you wouldn't be a toxicologist to say how it affects somebody, but the fentanyl itself, you would be an expert in, but not how it affects somebody else or anybody.
I would be able to identify, however, yes, not say how it can affect an individual because everybody is different in that aspect.
And I'm not going to ask you to do that, but were there any other substances found during that test? I mean, inert substances, can you tell what was with the fentanyl?
I was unable to determine what else was with the fentanyl aside from the 4A and PP.
Were you testing specifically for that, or were you testing for a panel of drugs?
The testing consists of a panel of drugs. Our drug method can identify hundreds of different drugs, so we do not specifically hone in on one specific drug. We look for any and all drugs.
So if it was baby powder, would it show in your test result that there was the presence of baby powder, but you wouldn't report it because it's not illegal?
I am unsure. I have never tested baby powder yet.
Do you have your full report with you?
Yes.
When you go down, and I'm looking at one of the pages down, I believe it's page 14, there's a list of certain things in the library. It says methyl benzoyl formate. Is that something that is found in your test? What are these?
Oh, I'm sorry. I do not. I'm not familiar with what form you're referring to.
You're talking about the data.
Yeah. I'm looking at the data that comes
okay.
along with the report. Okay, there are certain other things that I'm not entirely certain what I'm looking at, and that's why I wanted clarification from you. I definitely see that the fentanyl is included in that, but there's certain other chemicals like oxybus. You know what that is?
I am unsure what that is.
Triprolidine.
I'm unsure what that is as well.
Dimethyl benzoic acid.
That could be a cutting agent. However, I'm unsure. We just identify any controlled substances.
Okay, so this could be. What is the level that you would be able to determine a positive test on? So, for an example, if I have a cutting agent and I have by volume a pound of it, and I have just a pinhead of fentanyl, would you be able to get a positive test from that?
Potentially. Our instruments are very sensitive, and depending on how much of the sample is tested, our instrument is very sensitive and potentially would be able to pick up a very small, minute amount of fentanyl.
So if it was 1/10,000th of the mixture, it could be positive?
Potentially.
What fentanyl color is it?
The fentanyl powders that I typically see in the lab can be white, tan, there was purple before. It can be a variety of different colors within my experience.
What's the fineness of of fentanyl? Is it a gritty substance, grainy, or is it fine and silky? Could you explain that for us?
The fentanyl powder that I have analyzed throughout my career has come in all different shapes, forms, and sizes. So it could be very gritty, could be very smooth, could be hard. It just depends on the form that it is submitted in.
You see it pressed into pills, don't you?
That's correct.
Okay. Is it a sticky substance? Does it bind together with itself?
Whenever the fentanyl is, I have found it in pills, it is more of a hard substance, and then once the pill is broken apart, the powder will come out into soluble form.
What's the fineness of that powder?
What's the
Compared
question,
to-
sir?
What's the fineness
Oh.
of the powder? Like more of a sand? I'm asking because I don't know.
The fineness, like I said, it depends on the form that it's submitted. Sometimes it's very fine and very like a powder. Other times it's more gritty, more sandy.
Would you find it in a dust? Could it be airborne?
It potentially could be airborne.
No further questions. Thank you.
Thank you. Redirect examination.
No questions, Your Honor. Thank you.
All right, Mr. Meter, you may step down. Thank you.
Thank you.
Mr. Shapiro, you may call your next witness.
Your Honor, the state will not be calling any further witnesses.
You rest at this time?
Yes, Your Honor.
Right, ladies and gentlemen, as you heard, the state of Ohio has rested. That means the state has presented all the testimony it intends on presenting in this case. The next step in this trial is to afford the defendant an opportunity to present evidence if he desires. He's not required to do that, but he has the right to do that if he chooses. But before we get to that stage, I need to discuss some legal matters here briefly with the lawyers outside the presence of the jury. So you're going to take a brief break. You want to go use the restroom, do that, but then don't hang out in the hallway. Go back to the jury room, just wait. We're going to deal with the legal matters that we need to address out here. Shouldn't take too long, and we'll bring you back in here to resume. So please remember, though, even though the state is rested, you're still not permitted to talk about the case amongst yourselves. So please don't do that. Again, don't let anyone talk about it with you in your presence. And no investigating and researching any issues involved in this case. We'll take a brief recess, or at least you will. We'll do what we need to do, and we'll continue on. So if you want to bow to the jury room, all rise.
duty was the defendant's intention at this time?
Your Honor, the defense would rest. We don't have any witnesses.
All right. So ladies and gentlemen, as you've heard, the defense has rested. That means you have now heard all the evidence that each side intends on presenting in this case. There are 2 steps that remain to be completed in this trial before you get to begin your deliberations. The next step is that I'm going to provide you with the instructions of law. After that, then each side gets an opportunity to make closing arguments. So we're going to start right now with the instructions. I can't hear you. Oh. Yeah, why don't counsel approach for 1 second first? Thank you. All right, so I'm going to provide these instructions for you now. Now, I am required to read them to you. As I mentioned earlier, you are going to get multiple copies of these in writing back in the jury room with you when you're deliberating. So I'm not, again, expecting you to memorize what I tell you. But I am required to read them to you, so I'm going to do that at this point. I'm also going to put them up on a large screen so that if you want to follow along with me when I'm reading, you can do that, though you don't have to do that if you don't want to. You can sit back and listen as well. So we'll do that, get started with that right now. All right, ladies and gentlemen, you've now heard all the evidence. The court and the jury have separate functions. The jury decides the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept the instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own idea of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he's been charged with criminal offenses. The fact that it was filed may not be considered for any other purpose. The pleas of not guilty entered by the defendant to the charges is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt that's based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, evidence is all the testimony received from witnesses, the exhibits admitted during the trial, any facts agreed to by counsel, and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial, or it could be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which that witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. As an example, if you awake in the morning and see the ground is covered in snow, that is circumstantial evidence that it snowed earlier. Likewise, if you see human footprints in sand, that is circumstantial evidence that someone had previously walked there. Excuse me. To infer, to make an inference, is to reach a reasonable conclusion of fact which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments. The opening statements and closing arguments are designed to assist you. They are not evidence. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Statements that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. If the court sustained any objections concerning any statements made during opening or closing arguments, you must disregard such statements by any attorney. A number of exhibits and the testimony relating to them have been introduced throughout the trial. You will decide what weight, if any, the exhibits should receive in light of all the evidence. These exhibits may include, but are not limited to, documents, reports, video and audio exhibits, and other physical items. If there is a copy of an exhibit, you should consider it the same as an original. If there are deletions or redactions, you must not consider those parts. The numbering or lettering of the exhibits that you take to the jury room may not follow consecutively. There are several reasons for this. An exhibit may not have been submitted by the party who produced it during the trial, or the court may not have admitted an exhibit because of legal or procedural reason or ruling. Do not draw any inference because you do not have a particular exhibit. You will have with you in the jury room as exhibits audio and video recordings which are introduced into evidence. If you wish to listen to or view any of these recordings, there is equipment in the jury room which the bailiff will assist you in setting up and instruct you on how to use so that you may consider this evidence. You are the sole judge of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will use the test of truthfulness, which you will use in your daily lives. Now, these tests include the appearance of each witness upon the stand, the manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which the witness testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem to be proper. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. Generally, a witness may not express an opinion. However, one who follows a profession or a special line of work may express an opinion because of their education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based on that assumption. You must determine whether the assumed facts upon which an expert based an opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of an expert. In determining its weight, you may take into consideration the skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility and the weight to be given to the testimony. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. You are also not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, as for the specific charges, I'm sorry. In count 1, the defendant is charged with possession of a fentanyl-related compound. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about May 23, 2023 in Lake County, Ohio, the defendant, Levon Stanley, knowingly obtained, possessed, or used a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. Now, the following words contained in the offense of possession of a fentanyl-related compound as charged in count 1 are defined as set forth below. Knowingly, a person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he obtained, possessed, or used a fentanyl-related compound, or a mixture, preparation, or substance containing a fentanyl-related compound. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Now, possess means having control over a thing or substance, but possession may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. A person has possession when he knows that he has the object on or about his person or property or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Possession of a thing or substance can be either actual or constructive. Actual possession exists when the circumstances indicate that a person had a thing or substance within his immediate physical control. Constructive possession exists when a person was aware of the presence of a thing or substance and was able to exercise dominion and control over that thing or substance, even though that thing or substance may not have been within his immediate physical control. Both dominion and control, and whether a person was aware of a thing or substance's presence, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. Ownership is not necessary. A person may possess or control property belonging to another. Fentanyl-related compound. Fentanyl is a fentanyl-related compound. In count 2, the defendant is charged with tampering with evidence. Before you can find the defendant guilty of this offense, you must find, beyond a reasonable doubt, that on or about May 23, 2023 in Lake County, Ohio, the defendant, Levon Stanley, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, altered, destroyed, concealed, or removed anything with purpose to impair its value or availability as evidence in such proceeding or investigation. Now, the following words contained in the offense of tampering with evidence as charged in count 2 are defined as set forth below. Knowingly, a person acts knowingly regardless of his purpose when he is aware that his conduct would probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed in the mind of the defendant an awareness of the probability that an official proceeding or investigation was in progress or was about to be or likely to be instituted. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Official proceeding means any proceeding before a legislative, judicial, administrative, or other governmental agency or official authorized to take evidence under oath, and includes any proceeding before a referee, hearing examiner, commissioner, notary, or other person taking testimony or a deposition in connection with an official proceeding. Purpose. A person acts purposely when it is his specific intention to cause a certain result. It must be established that at the time in question it was present in the mind of the defendant a specific intention to impair the value or availability of the item or thing as evidence in the proceeding or investigation. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all the other facts and circumstances and evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Now, as you will note, it is alleged the offenses charged took place on or about May 23, 2023. It is not necessary that the state prove that the offenses were committed on the exact date discharged in the indictment. It is sufficient to prove the offenses took place on a date reasonably near the date claimed. It is also alleged that the offenses charged took place in Lake County, Ohio. Before you can decide whether the state of Ohio proved beyond a reasonable doubt all the essential elements of the offenses with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offenses were committed in Lake County, Ohio. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty of one or both of the offenses charged. If you find the state proved beyond a reasonable doubt all the essential elements of one or both of these offenses charged in the separate counts in the indictment, then your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of one or both of the offenses charged in the separate counts in the indictment, then your verdict must be not guilty as to such offense or offenses according to your findings. All right, that concludes my instructions at this point. I have some concluding remarks before you begin your deliberations, but at this point we're going to proceed with the closing arguments. As I've mentioned throughout the trial, what the lawyers say is not evidence, but closing arguments are an opportunity for each side to summarize for you what they believe the evidence in this case has established. The state of Ohio, having the burden of proof, gets the opportunity to go first, and then the defendant gets the opportunity to make a closing argument. And then the state, because they do have the burden of proof, will get an opportunity to make what's called a rebuttal argument. So for the state of Ohio, Ms. Brown?
Thank you, Your Honor. Yes, thank you.
You ready for it now? Ms. Brown, you'd like to have it open now?
Yes, Your Honor.
Yeah. Unplug it and plug it back in. Click on the top of the screen.
The screen's not showing it?
Well, the screen is showing something. It's not showing the PowerPoint.
No, it's showing.
Hang on.
Mine's not hooked up.
What?
Close your PowerPoint, open it again.
You gonna
Close the program. Apologize for this, Your Honor. I'm sorry.
That's all right.
We're going to, Ms. Brown has a PowerPoint to present, and we're just going to
That's
close
fine.
that.
Don't worry about it.
Thank you very much, Your Honor. We've been using my computer the whole time.
There you
There
go.
we go. Thank you, Your Honor.
You want to put a wood bowl or what? Are you good?
Good morning, everyone.
Hang on a second, Stan.
Get out of your way.
Thank you. Before I start, I would first like to thank you all for the attention that you've been paying to all of the evidence and testimony presented throughout this trial. I know that it's been a lot of information to process, so I appreciate you all for paying attention to all of the evidence. You've heard all of the testimony and you've seen all of the evidence presented. The defendant, Levon Stanley, was driving on Reynolds Road in Mentor-on-the-Lake, Lake County, state of Ohio. Officer Brodzinski gets behind the defendant. The defendant panicked and threw his fentanyl out of the window. As the evidence has shown, the defendant is guilty of count 1, possession of fentanyl, and count 2, tampering with evidence. Counts 1 and 2 have a few elements in common, those being the date and location of the offense and the fact that the offenses were committed by the defendant, Levon Stanley. You heard from Officer Brodzinski and Lieutenant Messenger that the offenses were committed on May 23, 2023 in Mentor-on-the-Lake, Lake County, state of Ohio. You also heard and observed both officers identify the defendant, Levon Stanley, as the person who committed these offenses. Count 1, possession of fentanyl. Under count 1, the state has shown that the defendant, Levon Stanley, did knowingly possess fentanyl, and that fentanyl is a Schedule II controlled substance. Under count 2, the state has shown that the defendant did, knowing that an investigation was in progress or likely to be instituted, knowingly alter, destroy, conceal, or remove a fentanyl-related compound with the purpose to impair incidence. In breaking down the elements of count 1, we'll start with the fact that the substance found on and in the defendant's vehicle is fentanyl, and that fentanyl is a Schedule II controlled substance. Officer Brodzinski and Lieutenant Messenger testified that swabs of the white powder found on and in the defendant's vehicle were collected at the scene. Swabs were taken from, as you saw, the roof of the vehicle, the passenger door handle, the passenger door, the passenger seat, under the driver's seat, and on the windshield. All swabs that were tested were sent to the Lake County Crime Laboratory and tested by forensic analyst Tyler Meter. Each of those swabs tested from the interior and exterior of the vehicle came back as containing fentanyl. You heard from the forensic analyst that each swab tested came back as containing fentanyl within a reasonable degree of scientific certainty, and that fentanyl is a Schedule II controlled substance. Continuing on with count 1, the state has shown that the defendant did knowingly possess the fentanyl in this case. You've received definitions from the court regarding the definitions of knowingly and possession that you will use in your deliberations. Generally, knowingly means that someone is aware that their conduct is of a certain nature. So in this case, that the defendant is aware that he was in possession of drugs, of fentanyl. To possess generally means to have control of something. So in this case, the fact that the defendant had control over the fentanyl. The state has shown that the defendant knowingly possessed the drugs that were collected in this case. It is abundantly clear from the evidence presented throughout this trial that the defendant, Levon Stanley, was aware of the fact that he possessed these drugs. Officer Brodzinski is behind the defendant. The defendant finally comes to a stop, and Officer Brodzinski sees what he describes as a puff of smoke emerge from the defendant's window. You saw footage of that. You saw footage of the particulate matter exit from the passenger window and settle over the roof of the vehicle. It's difficult to see in the video because it happens quickly, but you heard Officer Brodzinski testify that he saw this happening in real time. He saw it with his eyes and he called it out over his radio as it was happening. He testified that he was paying close attention to the defendant's vehicle because at the time he didn't know what he had on his hands. He saw that the defendant was not stopping, that he was going over the double yellow lines, and he didn't know if he had a distracted driver or an elderly person having a medical issue. So he was paying close attention to that vehicle. And in real time, as it was happening, he saw that smoke emerge from the passenger window and settle over the roof, just as you saw. The fact that the defendant is aware of this fentanyl is also evident by the fact that it's still floating in the air when Officer Brodzinski first approaches the defendant. Within a few minutes of being near this vehicle, Officer Brodzinski says, "What's the powder all over everything?" The existence of fentanyl all around everything on this scene was so prevalent that Officer Brodzinski commented on it almost immediately upon reaching that vehicle. The defendant was certainly aware of the existence of this fentanyl. If you look at the concentration of fentanyl in the air that was captured on Officer Brodzinski's body cam, that is clear. There was fentanyl in the interior of the vehicle. This is a photo of the passenger seat where the defendant's jacket was sitting. There was so much fentanyl that an outline was left on the seat from where this jacket was. There was fentanyl on the floor of the vehicle, on the passenger door. There was fentanyl all over the exterior of the vehicle, on the roof, and on the windshield. And the location of where we see the largest concentration of fentanyl in this case is consistent with the defendant throwing the fentanyl out of the window. The fentanyl is expelled from the passenger window and settles over the roof, over the front portion of the roof where the defendant is sitting. And that's consistent with what we see in the video where that puff of smoke emerges from the window and settles over the roof. The state has also shown that the defendant had control over the fentanyl in this case. He had to have control over the fentanyl to throw it out of the window. And additionally, the defendant was in control of the vehicle. He was in control of a vehicle that had fentanyl all over it and all in the vehicle. The defendant was the sole occupant of this vehicle. As you saw, there was no one in the passenger seat, no one in the back seat, no one hiding in the trunk, just the defendant alone with this vehicle covered in fentanyl. He had control over that vehicle and everything in it, including the fentanyl. He had control over that jacket that you saw him put on when he exited his car, the jacket that had the powder all over it. Now moving on to count 2, tampering with evidence. The state has shown that the defendant was aware of the fact that an investigation was in progress or likely to be instituted. Officer Brodzinski got behind the defendant and he initiated his lights and sirens. He pursued the defendant for almost 2 minutes until the defendant stopped. The defendant was aware of the fact that an investigation was in progress the moment that Officer Brodzinski got behind him and turned on his lights and sirens. If you're driving and an officer gets behind you and turns on their lights and sirens, that's evidence that an investigation is in progress. And the defendant was aware of the fact that if he had been stopped and that fentanyl had been found on him, that an investigation into that fentanyl would have been instituted, which is why the defendant threw the fentanyl out of the window. You see in this footage that the defendant, at multiple points while he's not stopping, while Officer Brodzinski is behind him, he goes over the double yellow line. And Officer Brodzinski said that this was an indication to him that the driver may have been distracted. And this is right before we see the defendant throw the fentanyl out of the window. He's in his car, not stopping, and we can infer that he's trying to figure out what to do with the fentanyl that he has in his car. And as has been testified here, the defendant did not stop for 1 minute and 45 seconds. And that doesn't sound like a long time, but in watching this video, again, you can see just how long it took for the defendant to actually stop while Officer Brodzinski was pursuing him this entire time with his lights and sirens on. The state has also shown that the defendant removed the fentanyl from his vehicle.
I got smoke coming out of the inside of the vehicle as well. I think it's cigarette smoke.
As you heard, Officer Brodzinski calls out, "I've got smoke coming out of the vehicle as well." He calls this out in the moment as it's happening, and this is the moment that the defendant throws his fentanyl out of the window. He tried to get rid of the fentanyl completely by removing it from his vehicle, but as you saw, it ended up over the roof and some in the interior of the vehicle as well. It is also clear that the defendant expelled fentanyl from his window when he stopped the vehicle and when Officer Brodzinski called it out over his radio, because the amount of powder in the air dissipates over time. I'm going to show you 2 videos that we've shown you throughout this trial from the beginning of Officer Brodzinski's interaction with the defendant. And you'll see that at the beginning, there's more particulate matter in the air, and this is because this is right when the defendant threw the fentanyl out of the window. And then when Officer Brodzinski goes back to pull the defendant out of the car, there's less particulate matter in the air because it's beginning to settle. This is further in time from when it's thrown out of the window.
First of all, you got your head bright lights on coming right at me and you didn't dim your lights.
My light out.
Okay.
So as
All
you
right.
can see, this is at the
For
beginning
my own safety, you have any
of the
gun, knives,
interaction. You
weapons in
can
the
see
vehicle, anything
all
like
of
that?
the
Okay, let me get
powder
your license.
in the air.
Yeah, you know what, give me a second just to take a look at this first, okay? Is this your current address, Parma Heights? Okay, what brings you out here tonight? Your coworker? Okay.
And then this is after Officer Brodzinski pulls the defendant out of the car. As you can see, there's less particulate matter in the air at this time because
All right,
at
so
this
I'm going to
point
have to
it's
ask you to go
beginning
ahead
to
and step out
settle.
of the vehicle for me. If you could just walk to the back of the vehicle for me.
The state has also shown that the defendant acted with purpose to impair the value of the evidence in this case, the value or availability of the evidence in this case. We can't look into the defendant's mind, so purpose is to be inferred based on the circumstances that we have here. Lieutenant Messenger confronted the defendant about the white powder on his car, as you observed. The defendant's reaction to being confronted about this, rather than saying, "What do you mean, what powder?" The defendant's response was, "I ain't got no drugs." He already had an answer prepared. He wasn't surprised by this question because he knew that he had fentanyl on him, and his purpose was to get rid of the evidence to make all of this go away. And before that, Officer Brodzinski asked the defendant about the powder, and the defendant said that it was smoke. Smoke from a marijuana cigarette that, as you saw, was not lit when Officer Brodzinski approached the defendant. The defendant's purpose was to impair the value or availability of the fentanyl in this case. When the defendant finally stopped his car and threw the fentanyl out of the window, he did this so that it could not be used against him. Some of the fentanyl landed on the vehicle and in the vehicle, and it was able to be swabbed. But the defendant did succeed in getting rid of evidence because, as you heard, not all of the fentanyl was able to be collected because it was spread out all over the vehicle. So we're not able to tell you today how much fentanyl the defendant had on him. Some of it, as you saw, blew away in the wind. The evidence presented here today has been clear. The defendant possessed fentanyl and tampered with evidence. There was fentanyl in the interior and exterior of a vehicle that was in the defendant's control. The evidence that we have seen has been consistent with the fact that the defendant threw his supply of fentanyl out of the window. It blew out of the window and it landed up, as you saw, on the roof, right over where the defendant was sitting. And not to mention however much of it blew away in the wind. The defendant is guilty of possession of fentanyl and tampering with evidence. Thank you.
Thank you. Mr. Deeb for the defense.
Thank you, Your Honor. Ms. Brown.
Ladies and gentlemen, thank you for your patience. I'm glad that we can get this done fairly quickly for you. And I appreciate every chance I get to look over you guys. I can definitely tell you guys are paying attention. And I believe Mr. Stanley really does appreciate that because he wants people that are going to listen to everything, absorb everything, and understand it. Now, in this case, he admits that he was smoking marijuana. And he admits that anyone would be nervous when they get pulled over. He tells the officers they can search the car when he's talking with the messenger. He's telling them that. As she's standing at that side where they're saying a ton of fentanyl is. Now we can go through the exhibits. I showed you Exhibit 5 before. Exhibit 5D. Yeah, is on there?
Yes, sir.
They're going to get this back in the jury room. Exhibit 5D. You see there's smudges in there. And that doesn't look like a fine powder that's settling on there. It looks like quite a lot. It looks like streaks. Not just like a dust that settles over everything. I'm going to take a close look at that. Also, in Exhibit 4C, we have the marijuana cigarette that he admits to smoking. Strong odor of marijuana coming from the car. Of course he's nervous. He thinks he's going to get an OBI. He just admitted to using marijuana. So that's when he says he has no drugs. He had marijuana, but that wasn't what he perceived. However, you look at the center console, they show you where they found it. There's no dust on any of this. The way they're talking, dust would be everywhere. It would be persuasive or pervasive. And it would have just covered everything. It doesn't pick or choose. It just goes everywhere. It's not on that center console. And one of the other pictures that you will see is that center console. It's when Lieutenant Messenger is going through the car, and they show her swabbing it from across the car. Exhibit 6E for the state. This is that center console, in front. I want you to look right here in the front there. An ashtray with ashes in it. The officer said he didn't see any ash. There's ashes in that ashtray. You'll get a close look at this. It's going to be back there for you. So what took him so long to stop? Putting out his cigarette, making sure that it was out, and it was just sitting there. It was going to smell like marijuana because he had just smoked. The officer even says, "I see smoke coming out of the car." Now, any particulates would be different than smoke. Smoke is very light, airy, and just dissipates. When you watch that video in real time, I don't doubt that the officer saw it. But when you look really close, you see something. But when you look at the amount of, this is Exhibit 6A, the amount, if that came out of that car, it would be a very big cloud, and it would be very obvious. And this goes to the front of the car, and it covers the front of the car and the hood. Now, from inside the car, throwing it out, there's nothing on the interior of the window. If it's sticking to everything else, why is it on the interior of the window? I don't doubt that there was this dust and fentanyl in the car. How it got there, that's the concern that I've been wondering myself. And I would believe Mr. Stanley would be also, and is. That's the vehicle he's driving. They have you look at the marks on the seat. In Exhibit 6F, which you'll have, this picture. Can you see it, Mike? You moving over? They say his jacket was over there. His jacket was picked up, so took this with it, but there's still dust over here. So that was there beforehand. That was a smudge. Nobody smudged it, nobody touched it. This has been on this car for a while. There's nothing on that top rack, the black bar on top. I would believe that based on all this information, driving the car, it was blown off in some manner or to some extent. He goes to Colin when he's playing basketball. He doesn't have any tie-offs or anything on him. He's got no information about drug purchases, whether he's going to use something. There are no accoutrements that go along with drug use. He's got a joint, and that's it. He doesn't have anything that he would be using any opioids with. They didn't present anything like that. There's no evidence of that. If that were the case, then it would be there. There's no tie-off. Where's the container? And how is he getting it out the window and up over the car, yet all down the side? I mean, the officer doesn't see any movement. In order for him to go that far, being a fairly large guy, we don't see the car move at all. We don't see anything. If they want to believe that that's being thrown out that passenger window. When you look at it, especially when you look at it from these, for how big it is and the expansive area, that foul would have been much bigger and much more visible than that car when you see it stop. There's no wind at that point. You're not driving. There's no air flowing over. The officer said that there was some wind, right? But to throw it out, to have it cover that side of the car and the top of the car. Now, the officers, he said, my heart's pounding. You know, opiates are downers. People know what opiates are. Fentanyl's an opiate. Thought maybe cocaine, that would get your heart pounding. That's a stimulant. And he doesn't know what's going on. Is he manufacturing that feeling? Or is he just excited? And he says, I had a burning in my throat. Well, there's stuff in the air. We don't know what that's from. But then the other officer tells you, yeah, we're back at the station we talked about and we said we're having those issues. Yet none of that's documented. None of that's documented. And the time difference, how are they getting their stories together? I even asked them if that would have been something that they would have supplemented. When it came back, they said, oh, yeah, with this powder in the air, we should supplement that because this is how we were feeling. And the officers know this. Fentanyl is an extremely dangerous drug. I'm not going to bring it in here to put everybody at risk, because exposure puts you at risk. So they don't want to bring it in. Okay? I'm glad they don't. I don't want to be exposed to it. It's very easy to overdose. And in this case, Mr. Stanley was driving this vehicle. The officers were searching the vehicle. They're up there with no mask, no gloves, no nothing. And with the dangerous nature of fentanyl, something would have happened. Not to mention, they let him drive home. He was very cooperative. He's sitting in the back. He says he doesn't have any drugs. They keep searching his car. He doesn't know what that is. At some point, it got in his car. And at this point, we have no idea how, when. He didn't destroy that. It would have been a tie-off. It would have been on his hands. In certain locations, look at the pictures. You look at the passenger part where the feet are. There's some on the door, but there's nothing on the passenger floor. You try and look, and you don't see that dust. But you see it on the seat, and then you see it where they say his jacket is, and it's underneath there. And then you look at it on the side of the car, and it's kind of like sprinkling down, like it's like an icicle kind of formation where it just goes down and it catches. But on the inside of the window, there's nothing. So when he's out in the back of the car, he doesn't know he's being arrested. They keep telling him that, but it's not illegal for an officer to lie to you. It's a de-escalation tactic so that they can talk to people where they don't get upset. And if he thinks he's not going to be arrested, it keeps him calmer. But he's in the backseat of a patrol car where he can't get out. And he keeps wondering what he's under arrest for. And he says, what? For what? What are they investigating? He doesn't say, oh no, they're going to find this. Oh no, they're going to find that. In fact, he tells me at the very beginning when he's sitting in that car with Officer Messenger, go ahead and search it. And she's at that window right there, where they're saying all this tangible dust is, and it's collecting very well. They don't test what's back in the car to see what that's from. The car's dirty. And he's going to have some on him from his feet. If it's in the car, there's transfer. Now, to go through and look at everything, he doesn't stop, okay? And that's a problem. But the officer even told you he was investigating him at that point for not dimming his lights. And why was he taking so long to stop? Like evidence of an impairment left of center. He's not investigating possession of drugs. And Mr. Stanley, if it were the fact that they're absolutely correct and this did happen, which we disagree that he never threw it out, but there was no investigation imminent or that would have been starting. He was being investigated for a traffic violation. And if they would have found the drugs, then they would have instituted. The prosecutor even told you that. They said, if they would have found the fentanyl, Mr. Stanley knew that if they found the fentanyl, they would start an investigation of that. That was their closing. And he had no idea. He maintained his position. He was cooperative with them. They looked through his phones. One of them didn't work. The other two they looked through, and there's no evidence whatsoever. Not of a purchase, not of a sale, not of how is he going to get it, where am I going to get it from. There's nothing in there. And he has no idea the police are going to be coming in and taking his phones. He didn't even go through them beforehand. He didn't know they were going to take them. So it's not like he deleted information. When they dumped his phone to get all of his data and all those old new messages, whatever apps that are on there, when they have all that information, they come away with nothing because there was nothing. There was no drugs. The fentanyl on that car must have been extremely weak. The crime lab gentleman, Mr. Meter, told you that their machines are extremely sensitive. And if there is even a minute portion of that is fentanyl, their equipment will figure that out and they'll say yes to the presence of fentanyl. Now, with the dangerousness of fentanyl, the fact that it's being able to be touched, people move around the car, somebody would have gotten sick. And they let him drive home and he wasn't sick. And he'd been in that car. So nobody got sick. So in all likelihood, fentanyl got there at some time, in some manner, but it was extremely weak, or however it got there, drone on there, drove through a cloud, did something. But the marijuana was no joke. And they didn't do any investigation into that. She just talked to him for a second, and she says his hands were shaking. His hands weren't shaking. You can see on the officer's video that he's handing documents over, he's doing everything just fine. He's not shaking, but he would be nervous. Like we talked about before, one of us was nervous just for a traffic stop. Imagine if you've had 3 or 4 drinks, or if you just smoked a joint. How nervous are you going to be? Because you can't hide that. And you know the officers are going to gear in on that. Now, taking the swabs and looking through all those pictures, you can see that is a lot of dust. I want you to focus on that and think about that cloud that you saw. And how did it settle so fast and so wide, the very front of the windshield? How did it get all the way down there? And how did it get to the top back? Anything's possible. But when you look at that, it's not probable. And if it's not probable, it creates a doubt. Now, even in your minds, you may think, maybe he did that. But we have to look beyond a reasonable doubt. The most serious of your affairs, would you rely on that? And at this point, we know that that was there. Whether he knew what it was, whether it was a drug or just a powder, there's no evidence that he knows what it is. And the puff of smoke and the stuff on the car, there's evidence that that has been there for at least some time. With the smudges on that panel, the fact that it was under his jacket, on that seat, that he was smoking, because you see the ash in that picture in the ashtray. You know, they come out of which side. The officers didn't know what to do. But you know one thing? When you look at that video, when you watch them go around the cars, you see some of their body cams, not once did his lights go down. That just kind of goes right out the window as soon as they come up to him. There's no investigation for that, and he gets one citation, and then he's on his way after an hour. Still wondering what a tie-off looks like, but the officers seem to be pretty sure. But that's what they thought that they would find. They didn't see anything come out of the car while he was driving. The officer didn't know what was going on at that point, so he's focused on everything. He doesn't know what's going to happen. So he's making sure he's tagging on everything. They even looked on the side. You'll see in the body cams, they look to see nothing. Look on the body cams, look down at the floor underneath that door on the cement and on the grass. There's no dust right there. There's no collection. And if that were the case, it was thrown out and it covered the side of that car like they say, it would be there and be on the inside of the window. And he would have had to touch it with his hands. Nothing on his hands. They don't see him cleaning his hands. They see him sweaty. It would be stuck to you if it's a powder. And there's nothing about him cleaning his hands. We don't see that. And that would definitely cause him to have a reaction to it if it was direct skin contact. You know, if there was a container, there was a tie-off in the car, yeah, that's probably what happened. But in this case, it's not what happened. Just because it was on his car doesn't mean he knew what it was or what was there, because I'm sure nobody would drive around with this if they knew it, if they had knowledge, or even if they had knowledge that, it's a good chance this is an illegal drug. Nobody would drive around in a car like that. Ladies and gentlemen, with everything that you've heard, we want you to process all the information. I think if it's plausible that little tiny puff that you can barely see, and when I showed it to the officer, played it from 209 to 224, and he says it's at 217, he didn't stop me. They told him to stop me when you see it. He didn't see it yet. At that time, it was smoke. For this amount of dust, that cloud would have been obvious, and it would have been large to get to where it was. So it wasn't how it happened. When he was stopping, he was putting out his marijuana cigarette because he knew he had to answer for that. Here, ladies and gentlemen, there was no knowledge that there was an investigation going on. He didn't tamper with any evidence, but if you believe that maybe he did, then one, there wasn't the investigation on. A traffic stop doesn't say, I'm investigating you for everything. The officer told you I was investigating for his driving, the lights and the driving. And he didn't know what that was. And he maintained to them, I have no idea. And he kept talking to them. He was honest with them, answered their questions. They had a good rapport. He and both officers had conversations. Not like somebody who would be extremely nervous about this type of situation. This type of situation would make somebody extremely nervous. One, if they even allege it, but if he had just done it, he would have been obviously nervous, and he would have reacted differently in his interactions with the officers. And of course, he's not going to say on several occasions, search my car. And he said that prior to them even telling him he was going to search. When he's talking to Officer Messenger. So we believe that not guilty on both charges would be the appropriate verdict. But that's where it lies with you guys. The triers of fact. These all are reasonable people. We appreciate the fact that you sat here, listened to me drone on, watch all the exhibits, listen to the prosecutor, myself, and pay attention. And we'd like you to do that one more time when you go back there and go through the evidence. See if it makes sense to you. We believe that you will find that they have not proven their case beyond a reasonable doubt. Thank you.
Thank you, Mr. Deeb. Mr. DePiero for the state.
Thank you, Your Honor. Ladies and gentlemen, I would like to first thank Mr. Deeb for his professionalism throughout this trial, conducting this trial. That being said, I disagree with just about everything that he told you guys when he stood up here, and I'm going to tell you why. During jury selection, I asked you questions having to do with whether or not you can apply your reason and your common sense to the evidence that you see and hear through the trial. You said, yes, I can do that. And that's good, because that's what a juror has to do. You evaluate the evidence, the testimony, those words coming out of the witness's mouth is evidence. Just like those photographs that you can look at and you view as evidence, we have to do the same thing with the words. And I remind you of that, and I highlight that to you because there was ample evidence in this case that that dust coming out of that car came from inside of it and that the defendant expelled it. Officer Brodzinski saw it with his naked eye. Here's a police officer who started his shift an hour and a half before in a clean car. Back seat was clean. He testified that he checked it. Nobody had been back there. And he sees a car coming at him with the brights. Okay, you know, it happens. Didn't turn him off. I guess, and he testified, I guess I'll just turn around and just see, you know, just mind him, like, hey, you're supposed to turn your brights off. You didn't do that. Then he got behind it, and the car wouldn't stop. Kept going. He testified, I didn't know what I had in my hands here. And I asked him, what were you looking at that point? He said, I was looking at everything. Here's a police officer who doesn't know what's going on in that car. Could be a medical issue, could be someone distracted, could be an OVI. So yeah, he's watching everything. That's his job. And so when that car stops and he's calling it in, he testified he's still watching it. And as many times as Mr. Deeb says that this puff of dust would have been more obvious, it was obvious. And as much as Mr. Deeb is arguing to you that the puff would have been larger, it was large. Large enough for a police officer to be sitting in his cruiser, what he said, testify, was 25 feet away, to see it and to immediately comment on it to dispatch because it was so large and obvious to him and out of place. Now, whether or not you can see it in the blink of an eye, sitting from a witness
stand watching it on that screen, that doesn't mean that it wasn't big and that it wasn't obvious, as Officer Brodzinski saw it and what he testified to, his evidence. Okay. Videos are helpful. They're good. I'm glad we have them now. We didn't used to have them. Before, you had the testimony of the officer. Now you have the testimony of the officer and a video. And I asked, every time we showed a video or a photograph, I asked the witness, does this fairly and accurately depict that? Well, you guys probably got sick of me saying it. They fairly and accurately depict it. They don't depict it with absolute 100% clear perfection. But that's how it was. That's how they looked. That photograph, that's what it looked like that night. The jury is to apply reason and common sense in evaluating and weighing the evidence. The defendant knew that an investigation was taking place. He had 1 minute and 45 seconds to know it, while he continues to drive when a cop is stopping him. And he doesn't stop. Why? Because he knows he's got those drugs. He goes, oh man, maybe he'll keep going. Maybe it's somebody else he's trying to pull over. No, because there's no other cars on the road. There was no reason why he couldn't have stopped right away. He didn't stop because he's trying to figure out what's he going to do with these drugs, because he knows that that police is going to find him. He's going to investigate and he's going to find him. Of course there was an investigation going on. From his perspective, certainly. And that goes to his purpose in getting rid of them. He didn't want to get caught with them. He didn't want to have them be available as evidence. Let's talk about reason and common sense. Let's talk about this marijuana. Okay? Mr. Deeb argues to you that perhaps he was OVI. Common sense. A guy who, if you look at it from what he said, the defendant, if you want to believe, he's smoking marijuana and he's worried about that he's going to get a DUI, and he sees a cop in the rearview mirror with the lights come on, and he's actively smoking this blunt, okay, marijuana. He's going to keep smoking it for 1 minute and 45 seconds when this cop is following him? Does that make sense, or does he go, oh, geez. He's going to keep smoking it for 1 minute and 45 seconds. And then even finally, when he decides, all right, I guess I have to stop, he's going to keep following me, and he stops. At that point, he's just got to take one more big puff. And Mr. Deeb's argument would have you believe that as the defendant sat in the driver's side of this Kia minivan, that his lungs were strong enough that he turned his head and blew it from the driver's side all the way to the passenger side, and it was such a large puff of smoke that this cop can see it from 25 feet away in the dark. That's some strong lungs. That doesn't make sense. But he had his answer ready when the cop says, what's all the power? He goes, immediately, it's smoke. By the way, the cop had been standing there for quite some period of time. And the smoke, it just disappears. How come it's still all in the air? He says that's smoke. Because he's got to stick to it. He threw it out the window, it didn't work out for him. It's stuck all everywhere. Got to say something, I guess. That's not smoke. That's these drugs. They just threw out. And they had just been agitated. That's why they're in the air. That's why Ms. Brown showed you that video in her PowerPoint of when Officer Brodzinski is at the side. That's at I think 32 minutes is the time index in the bottom of the screen. Watch that. It's everywhere. It's everywhere. Okay? And then the next video clip that was shown from the state's exhibit is 5 minutes later. Look at the bottom of the screen. There's nothing in the air. That's because it had been agitated recently in the beginning, and then it had time to settle. This man who is sweating and so hot profusely in this 50-degree day, but he's got to put that jacket on. He's hot. That's why he's sweating when he puts a jacket on before he sits in the cruiser. And he sits in the back of the cruiser and there's no particles, but then he starts moving around and reaching down here and this and that, and then there's particles all in the air. That's not a coincidence. That's evidence. Mr. Deeb argues that the odor of burnt marijuana, that means that this guy, yes, he was smoking. Think about your common experience of people who smoke. Cigarette smoke, usually what people are used to, smokers. Think about, you ever been in the vehicle of someone who smokes cigarettes all the time in your car? Whether they had just smoked or whether they smoked 1 hour ago, it smells like burnt cigarettes. Or their house, or their clothes. The fact that they smell the odor of burnt marijuana as opposed to raw marijuana does not necessarily mean that it had just been smoked. It doesn't make sense that this guy would be smoking when he knows he's about to get pulled over. It was the powder that he's getting rid of. And the evidence shows the path of that powder. The state's exhibits show the photographs that there's powder at his feet where he was seated. There is powder on the passenger inside door and armrest and the top of that windowsill as it went out and settled. Okay? And there wasn't any evidence that it was any on the floor because he had to fling it across. There's not going to be any on the floor. It's going to be on the armrest. It's going to be outside. Watch that video. 2 minutes, 17 seconds. Watch it over and over and over. You're going to see it quickly, faintly, because you're 25 feet away with headlights down here, and you're looking at the top of a minivan that's not illuminated, and you can't see the front windshield of that minivan from behind it. You can just see over the roof. So the bulk of that dust, the bulk of that powder, was at a point in the video that you can't see because it's down here. Okay? There's the roof of the car, the windshield goes like this. This is mostly where the powder was, some blew up here. Mostly here. You can't see that from behind, no matter how many times you look at it. He saw it come out in real life. He told you about it, he announced it on the radio. Lieutenant Messenger, she testified, I heard that call, I heard his voice, it was something odd, I got there fast. Whether or not he can sit here and watch it on the video later and identify it at the very second Mr. Deeb asked him, that's not, he remembers. That's the evidence. Excuse me. Watch that video, State's Exhibit 2, when he is on the side of the car, Officer Brzezinski. When you see the defendant says he's going to get his insurance out of his jacket. When the defendant reaches over and he grabs his jacket, you see, it comes off. Mr. Deeb wants to argue the powder was underneath before. It doesn't comport with the evidence. There's the outline of the seat of where it was. So the point is, it wasn't there before, and then it was there now. And the fact that it's in the air is evidence of recent agitation. Mr. Deeb showed you a bunch of pictures, and he wanted to argue that there's no powder in certain areas. I would submit to you, when you look at those pictures, and you look at the top from the passenger view, the powder is concentrated towards the front of the car, not the back. That is consistent with the path of travel that you see in the video and what he saw in real life. That is not a coincidence. It is evidence that that is how that was deposited on there. Why were you slow to stop? Officer Brzezinski asked him. And he says, because I was smoking. That doesn't make any sense, ladies and gentlemen. You decide if it makes sense. That he's going to keep smoking when he knows he's got a cop behind him and he's weaving? Now, Mr. Deeb keeps bringing up these smudges. Okay? And there's no evidence of the adhesion qualities of the powder that fentanyl is in. Okay? All we can present to you is what the officers saw. They took samples from various areas of that car, and every single one of them contained fentanyl, a fentanyl-related compound, from every single area. And there was painstaking work done to make sure that each swab was separated from the others. In the collection of them, you heard Officer Brzezinski testify about did it separately, packaged them separately. You heard Tyler Meter testify, and they drove everybody nuts going through all these pictures The reason I did that is to show you that there was painstaking effort to make sure that we did each of these separately. There was no cross-contamination. So every single swab that was taken contained the same thing, contained fentanyl. Okay, and it was fentanyl. Doesn't matter how strong it was. An element of the offense is not the strength. We don't have to prove how strong it was. That's not an element. We just have to prove that that substance that the defendant had contained some amount of fentanyl, an identifiable amount of fentanyl. Tyler Meter testified, I identified it as fentanyl as a matter of within a reasonable degree of scientific certainty. It's fentanyl. Doesn't matter how much. We don't know how much it is because he threw it out the window. They couldn't collect it. That's why he did that. Mr. Deeb argues to you that, they didn't find a tie-off. Okay? The officers testified that they were looking for some sort of packaging that this powder would have been in. And I asked Mr. Brosey, did you search that car? You searched every nook and cranny of that car? You searched the trunk, you moved around the athletic equipment, you looked underneath the seat, he looked in the glove box. Remember he said he checked the visor? No. And Lieutenant Messenger, when she confronted the defendant, he said, yeah, go ahead and search the car. He knew it wasn't in there. By the way, they didn't search everywhere. This defendant did leave the scene. He was patted down for weapons before he was put in the cruiser as a matter of safety, make sure he didn't have anything on him. Felt some phones, thought maybe it was a gun. It wasn't, it was 3 phones. Felt something else bigger. It was $1,500, wasn't a weapon. Coach's whistle. But we didn't search every nook and cranny. The fact that a container was not found does not mean that the evidence shows that he expelled it. Mr. D brought up how these officers didn't supplement their report about their effects. They didn't write it down. When I asked Officer Brodzinski about his heart pounding, I said, do you remember how that felt on scene? He said, yes, I do. And I asked him, do you think it was funny? He says, no, it wasn't funny. When Lieutenant Messenger was testifying about the effect, she said it was after, and they both said, we didn't have to go to the hospital. We didn't write it down. And keep in mind, these officers did not know for certain what this substance was. You see, they did their job. They investigated. They sent it for analysis first before they made assumptions and before they started pointing fingers at people. They didn't take him to jail just like they said they weren't going to because they didn't know what they had yet until it was analyzed. Now the evidence is before you. So the fact that he was let go, Mr. Deeb brought up, is indicative of the fact that these officers evaluated the evidence. They gathered evidence and they looked at it before they started pointing fingers. And by the way, about this OEI, they did let him go. You think officers would have ever let somebody go who was OEI? No. The state doesn't have to prove how strong that fentanyl was. You don't have to prove the concentration of it. Just that the powder contained some amount of fentanyl, and that's what the evidence shows here. Sorry. Forgive me.
That's all right. Take your time.
Ladies and gentlemen, when you apply your common sense, it's not a coincidence. When the defendant, Tim Deeb's talking about the defendant driving that stuff in the car, you wouldn't be able to see through that powder. You'd put your windshield wipers on if you thought it was pollen or some other thing when you're driving. It's his car. Said he's coming from Collinwood, it's a pretty good distance. He would have put his wipers on. He had his brights on. You know when you put your brights on, everything's illuminated? It was just deposited on that car when he stopped it. That's what the evidence shows. Direct evidence is just as good as circumstantial evidence inherently. It's up to you to decide what it means. When you add up all of the direct evidence in this case and the circumstantial evidence in this case, It shows this defendant had those drugs. He knew it. He's the only one in control of that car. He's the only one in control of those drugs. He saw that cop about to pull him over, didn't give up. After a minute 45, and he said, damn, boom, tampering with evidence. Ladies and gentlemen, I ask you to evaluate the evidence. I thank you very much for your attention through this trial. And I ask you to find this defendant guilty of what he did. Thank you.
Thank you. All right, ladies and gentlemen, finish up with instructions here at this time. And you'll be able to begin your deliberations. So let me get these back up on the screen for you. All right, the court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and prepare your verdict. When you go to the jury room, your first function will be to select one of the jurors to serve as a foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. That person serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form is returned to the courtroom after you have reached a verdict. Once a foreperson is selected, you will commence your deliberations. Your initial conduct upon commencing deliberations is a matter of importance. It is not wise to immediately express a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused and you may hesitate to change your position even if you later decide you are not correct. You should consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after discussion of the case with the other jurors. Do not hesitate to change your opinion if you are convinced that it is wrong or if the discussion persuades you that you should. You should not, however, surrender honest convictions to be congenial or to reach a verdict solely because of the opinion of other jurors. The verdict must represent the considered judgment of each juror. To return a verdict, all jurors must agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on the law as I have given it to you in these instructions. Nothing that I have said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have a question during your deliberations, it should be discussed in the privacy of your jury room. It should be reduced to writing, noting the date and time of the question so that there will be no misunderstanding as to what you request, and it should be signed by the foreperson. It should then be delivered to the bailiff who will submit it to the court. Your question should not reflect the status of your deliberations. Please be patient and waiting for a response because the judge must consult with the lawyers for the parties before sending his response. The court will then attempt to answer the question as best as possible. Please keep in mind, though, that the court may not be able to answer all questions. Now, you will have with you in the jury room the following form of verdict. When you have reached a verdict, you will complete the form in the way which corresponds to your decisions and sign the verdict in ink. So here is the verdict form you're going to have back in the jury room with you. The first page has the caption of the case, and then it reads Count 1, possession of a fentanyl-related compound. And it reads, we the jury, being duly impaneled and sworn, find the defendant, Levon I. Stanley. Then you see an asterisk symbol followed by a blank line, then the words of possession of a fentanyl-related compound. Below that is the directions for the asterisk symbol, which read, insert in ink either the word guilty or the two words not guilty. So whichever decision all 12 of you reach regarding count 1, you'll insert that on that blank line, so it'll read, we the jury, being duly impaneled and sworn, find the defendant, Levon Stanley, either guilty or not guilty of possession of a fentanyl-related compound. You then see a line here preceded by the word dated. You'll place the date that it is that all 12 of you have reached that decision on count 1. Then you see 12 lines below that. Those are the signature lines for each respective signature to place his or her signature. So Ms. Christinger, your juror number 1, will go along the back row to Mr. Pulau, your juror number 6. Start back up in the front with Mr. Zukowski, your juror 7. We go along the bottom row to Ms. Walsh, who is juror number 12. So if you want to make a mental note of what number you are, that will be the line that you will be placing your signature on once you have reached a verdict on this particular count. Second page then has the verdict form for count 2, tampering with evidence, and it reads similar to the first count. We, the jury, being duly impaneled and sworn, find the defendant, Levon Stanley, and then again you see the same asterisk symbol with the blank line of tampering with evidence. You submit whichever word or words are in accordance with the decision all 12 of you reach. You then place the date that all 12 of you reached that decision, and then you place your signature on the appropriate line. So let's go back to the final concluding remarks. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. The court will place in your possession the verdict form as well as all the exhibits admitted into evidence during the trial. You will also be provided with multiple copies of these instructions. You will not be given anything else. During your deliberations, the court reporter will not be permitted to read back any of the testimony which you heard during the trial. You may not discuss or consider the subject of punishment. Your duty is confined to deciding whether the defendant is guilty or not guilty of the charged offenses. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon this court. You must also not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. The court also orders that you not take any electronic devices or books of reference into the jury room. This restriction will cover such items as cell phones, computers, dictionaries, law books, etc. If during the trial the court said or did anything you consider an indication of the court's view on the facts, or if you have the impression the court has indicated how any disputed facts should be decided, you must put aside such an impression. Nothing said in these instructions and nothing in the verdict form is meant to suggest or convey in any way or manner any intimation to what verdict I think you should find. That decision must be made by you based solely upon the facts presented to you in the courtroom. You're also warned not to discuss your verdict or the status of your deliberations with anyone except for your fellow jurors while you are deliberating until the verdict has been returned to court. So what that actually means, ladies and gentlemen, is what all 12 of you have to be present when you're deliberating. If you take a break, if you go to lunch, you can't discuss the case. If a few of you are sitting back here waiting, or you go to lunch with someone, you can't talk about anything having to do with the case. You can only do that when all 12 of you are present and you're locked in that jury room. Now, this order must be strictly obeyed. After your verdict is returned and announced in open court, you may discuss the case with anyone, though you're not required to do so. Whether you discuss the case with counsel or anyone else after you are discharged is a matter of your own free choice. In my preliminary instructions to you, if I said anything that conflicts with these final instructions control your deliberations and are binding on you regardless of what I said in my preliminary instructions.
Now, jurors who have been selected as alternate jurors are not permitted to participate in the jury's deliberations unless one or more of the regular jurors are unable to complete their service due to illness or some other misfortune, and we're happy that nothing like that happened in this particular case. Fortunately, it does not appear that our alternate will have to render any further service in this case. So Mr. Slensik, you were selected as our alternate juror, and it will not be necessary for you to serve any further in this case. Once the jury convenes in the jury room here in just a moment, you go in with them, take your badge off, gather your belongings, and then you're free to go at that point. You're discharged from any further service in this case. Now, even though you will not be required to render any further service in the case, the court must restrict you from discussing the case with anyone or from revealing to anyone how you would have voted had you been one of the original members. Once the jury has returned its verdict and it's announced in open court, you will be released from that restriction. You can talk about the case, anything having to do with the case, or what your thoughts or opinions were, and with whomever you please, though you're not required to do that. That's a decision for you to make for yourself. But at this time, I certainly do want to acknowledge and thank you for the service that you provided as our alternate. So thank you very much. All right, Mr. Pero, anything else for the record not for the record, excuse me, anything else you wish to discuss at this point?
No, Your Honor. Thank you.
Mr. D for the defense?
No, Your Honor.
All right, ladies and gentlemen, does any of you have any questions at this time? I'm not talking substantive questions with the law. If that's the case, you need to write that out. But procedurally, what you're going to do is you're going to go back to the jury room here in just a second. You'll select your alternate, your foreperson. Probably want to take a break at that point, but that's up to you. From this point forward, any scheduling or breaks or anything like that is going to be left completely up to you. You're going to decide if you want to take a break. You're going to decide if you want to go to lunch, how long you're going to go to lunch. Well, you're not going to go for 3
You'll decide all that stuff. The only thing I ask is that you let us know. So if you decide you want to take a break, hit the buzzer, Stan will come back there, and let him know before you go do that. We don't want to see you wandering the hallways while we think you're back there deliberating. So just let us know if you're going to take a break or anything like that. But it will be your decision from this point forward in that regard. But any other questions at this point? All right. Well then, you will now be retiring to the jury room. The first thing you should do again is select your foreperson, and then you are to deliberate upon your verdict. If you guys want to take your break, you can do that. Let Stan know. But whenever all 12 of you have agreed upon a verdict as to each count, you'll sign those verdicts in ink. You'll advise the court through the buzzer system there that Stan will show you what to do and to let us know how many times to press the buzzer, and it'll indicate what's going on. You will then be returned to the courtroom where your verdict will then be announced here in court. So at this point, you may retire and begin your deliberation.